Good morning, Flint. My name's Terry Bankert. This is WFLT 1420 AM radio. And yes, Lynn, that took an extra minute for me to set up. What I'm doing today is what I did 2 weeks ago. I have my video camera on, and I'm going to post part of this live program on YouTube. I'll tell you how to connect with that later if everything's successful. This is WFLT 1420 AM radio. This is a call-in station, 239-5733. Here's our question for today. If your elderly parent gets married to a gold digger who does not care for your parent and is only out for their money, and your parent starts an action for annulment of their marriage and then unfortunately becomes deceased, what can you do? This is a case hot off the attorney website from the Court of Appeals. It's a current Michigan case that was recently decided. And in this, basically the answer is that if your deceased parent began that motion to annul the marriage, they had to plead it right. And what I'm going to do today is talk about the law of annulment and the fact that this is a personal right. It's a right of the spouses, and that there are two different kinds of annulments. One when a marriage is just void because there was a prior marriage, or if it's voidable because of incapacity. But often, not often, a couple times in my career, I've had children come to me and say that their parent wants a divorce, they're incapacitated, the spouse is somebody the new wife is somebody they don't know, what can they do? And what is in effect here is that it's the married party's right to decide whether or not they want an annulment. So this is WFLT 1420 AM radio. This is my show, Know the Law. The topic today is annulment. You'll see this on a YouTube post later, and I'll direct you to my website in terms of how to read the longer article. Annulment and elderly parents. This was an action for annulment that was out of Wayne County Circuit Court. It was published this month out of the Michigan Court of Appeals. And in this, the children were found to not have standing to pursue an annulment started by their deceased parent. But as a little bit of background here, what does it take for a marriage to be valid in Michigan? Well, the parties must not be married already. Parties must not be of the same sex. Not to be too closely related. First cousins can't marry. Must be of marriageable age. That's to be a legal adult, but there are exceptions to that. Must be capable of contracting, which means of a legal age and not incapacitated. And must enter the marriage without fraud or duress. When you go into court, there's what's called a strong presumption that exists favoring a marriage's validity. Once there's a celebration of marriage and the contract for marriage is shown, the capacity and everything else necessary is just presumed. So whoever wants to challenge it has got a real high hurdle. We want people to freely marry, and we want those marriages to stick as best that we can. An annulment dissolves two categories of marriage. Marriages that are void ad initio, and if anybody knows Latin, tell me how to pronounce I-N-I-T-O. These are void from the beginning. Although not favored, they can be attacked after the death of one of the parties. The case that we're going to talk about is an exception to this. Voidable marriages, they're valid until somebody brings an action. Either party may file a petition or complaint for annulment, and how you talk to the court is you file a petition, you file a complaint, you file a motion, and the court talks back to you by issuing judgments or issuing orders. And you do it in the circuit court where at least one of the parties resides. So you don't have to go back to the state you were married in. You don't have to go back to the county you married in. You just got to live here. And if you've been in the state of Michigan and moved around, as long as you're in that county for 10 days, you can file. And actually, it's less than that. There are no length of residency requirements. If you're in the county residing there, you can file. A little bit more of background. Let's talk about the children of an annulled marriage. We have people that want to talk about annulments based on fraud, but what if there's children? Well, the children are legitimate. They're never thought to be other than that, and they're considered the legitimate offsprings of the party capable of contracting, and that's for the purposes of distributing an estate. The court provides for custody and support of the children of an annulled marriage, regardless of the grounds. So, if the marriage is annulled and mom's pregnant and has a child, Dad, you still have an obligation to support that child. You'd have that obligation if you were never married, so therefore the annulment won't affect that. Basically, what the court's going to do is they're going to treat the annulment separate from anything to do with the children. Parents, you have to support your children. You should do it with love and affection, guidance, give them a place to live and food to eat. And if you're not the custodial parent, you have to provide the other parent with those proceeds. In an annulment, now we're going to court and we're saying we don't want to be married. We're saying that we should never have been married because of various reasons. What happens to personal property? What if you signed a mortgage on a house? Or what if you bought a car and you on joint money? Well, property awards are distributed the same way in an annulment as in a divorce. So what we're really talking about here is that if you get married and you find out that the other spouse is incapable of bearing children and possibly has a sexual identity issue, these are some things that can be brought forward as grounds for void marriage or a voidable marriage. Attorney fees, same principles in a divorce. And the grounds for an annulment are bigamy, marriage prohibited by the relationship of the party, incompetence, that means mental incompetence, or underage marriage, fraud, duress, and the inability to have children. There's a presumption that people bond together in a union for one of the basic reasons of procreating. You have a right not to, and it's okay if parties choose not to, but if one party had the presumption that they wanted children and the other party was incapable, that's a grounds. But you need to raise that issue early. In this court case we're talking about, the wife's argument held up. She stayed married after it went through the Court of Appeals. This was a voidable marriage. It was based upon fraud or duress, and it wasn't because of bigamy or incompetence at the time of marriage, though the gentleman, as he got sick, may have become incompetent. It was voidable, and that was how it was pled. And this is a personal right, so that if your father marries a woman who is quite a bit younger than him, and you don't really know her, and you think it was just to get his money, and they're married, and he starts an annulment, and then he's deceased, that was a personal right of his to do that. And an action for an annulment of such a marriage can only be maintained by a party to the marriage contract, or where the spouse seeking annulment is under a legal disability.